of Bill C-281, the International Human Rights Act, to recognize this as a piece of legislation that brings together a number of important measures that advance human rights. I want to recognize the work done by my colleague and friend from Northumberland, Peterborough South. We were together in Mississauga about a week ago doing a town hall on this piece of legislation. And it was really incredible to see just the number of different communities that were represented at that event, the diversity of experience that's driving people to want to see this legislation passed. When I first got elected, I started sharing the story of my grandmother. My grandmother was a Holocaust survivor, and learning about her experience in Germany during the Second World War was a key motivator for me to get involved in international human rights work. And when I first got elected, I would go and share her stories and our family's experience with different people that I met. And very often I would hear people sharing their stories back of other kinds of mass atrocities, genocide, persecution that they had or their families had experienced that had led them to come to Canada. And one of the things that's striking about our multiculturalism here in Canada is that we have many people that have come to this country fleeing different kinds of persecution, mass atrocities, and genocide. That many of those who come to Canada have come as refugees. They carry with them the experience of trauma, of violence against their families, against their communities. And those communities, those that are themselves refugees or descended from refugees, have been a key motivator, I think, pushing this House to do more when it comes to defending international human rights and putting forward some of the concrete ideas that are around this bill. Right now, we see the horrific genocidal invasion of Ukraine happening. We see violent repression inside of Russia against civil society, pro-democracy activists and others. We see the heroic freedom movement taking place in Iran. We see the worsening human rights situation in Sri Lanka. We have the Uyghur genocide, other human rights abuses in China. So many different places and instances of human rights abuses. But this piece of legislation does not name specific countries. It's not about addressing individual human rights issues sort of as one-offs. It's rather about changing the framework in terms of the way the government of Canada approaches human rights, putting in place a framework that will push the government always to be prioritizing human rights in its foreign policy, to do that not just today but into the future, and to do that not just in the relation to particular hotspots we see, but to do that in general in every case. This bill is called the International Human Rights Act. A key aspect of it that relates to most of its provisions is accountability. I would say this is legislation that establishes accountability around human rights, and in two principal ways. It forces the government of Canada to be more accountable to Parliament and to parliamentary committees when it comes to human rights, and it also seeks to hold perpetrators of human rights violations accountable for those actions. So let's start by talking about the aspect of holding the government accountable. And do I have criticisms of this government, today's approach to human rights? Yes, I do. But this legislation isn't just about the government today. It's about establishing a framework whereby any government in the future, any government of Canada would be more accountable to Parliament when it comes to fulfilling their obligations on human rights. It would apply to future Conservative governments as well. It would apply to any government to say that human rights should be a central part of our approach to foreign policy. This bill requires the government of Canada to table an annual report in terms of the work they're doing on advancing human rights. And this would be a way of clearly signaling what work the government is doing, and maybe it would give parliamentarians an opportunity to identify absences, things the government should be doing and isn't. So this is a powerful accountability mechanism, and it's a jumping off point for raising questions, pointing out gaps, and asking the government to do more in certain respects. But the legislation also calls for that report specifically to identify prisoners of conscience, individuals that are detained around the world who shouldn't be detained, that Canada is advocating for their release. And there's been some debate in this sort of opening section of the bill. Is the requirement to list prisoners of conscience appropriate? Are there cases where the government might not want to publicly list prisoners of conscience because in fact, private advocacy would be more effective, not naming them publicly. So I'll say, first of all, I know the member who's sponsoring this bill, and those of us conservatives on the Foreign Affairs Committee will certainly be open to a discussion around reasonable amendments and hearing from witnesses as to how to strengthen aspects of this legislation. But I will say that any exception to the public naming of prisoners of conscience should be clearly circumscribed and sufficiently narrow, because what we hear overwhelmingly from people that have been detained, from their family members and advocates, is that bringing more attention to these cases is virtually always helpful. That when we say the names, when we talk about Hussein Khalil, for example, that when we bring more attention to these cases, that it is something that their families and their advocates want us to be doing, to highlight the fact that they're arbitrarily detained, to ensure that they aren't forgotten, and to put through saying their names, through speaking out about their cases, through calling for their releases, that we bring more attention and more pressure to that call for their relief. Now, may there be exceptions? Sure, and we should talk about as a committee how to refine those cases. But it shouldn't be carte blanche for the government just to not list names that maybe for some strategic foreign policy reason that they don't want to name. We want to be bringing as much attention to these instances of arbitrary detention as possible, because generally speaking, what we've heard from civil society is that bringing attention to these cases of arbitrary detention is helpful for those prisoners of conscience. So this is the International Human Rights Act. Accountability is a key part of it. One aspect of that accountability is holding the government of Canada accountable. They have to publish this report and identify prisoners of conscience that for whose release they are advocating, and it allows us to ask questions about, hey, why isn't this name? Why isn't this name? Suggesting names that maybe should have been on that list that weren't, and hope they are added in subsequent years to increase the work doing specifically to advocate for the release of people that are wrongfully detained. Another aspect of the accountability piece is an amendment to the Magnitsky Act. Now, I recognize the great work done passing the Magnitsky Act. This was passed by my colleague from Selkirk, Interlake, Eastman. It was passed unanimously in this House, and Canada was the first country, in fact, to adopt Magnitsky sanctions legislation. We've seen Magnitsky sanctions legislation adopted around the world. But the challenge with the Magnitsky Act is the Magnitsky Act gives a tool to the government when it comes to sanctioning human rights abusers. But that tool is only as good as its use. If we as a legislature empower the government, as we have, with the ability to impose Magnitsky sanctions, then the government doesn't actually sanction people who are abusing human rights, then we have not used that tool and it hasn't had the desired effect. So looking at the fact that there are many countries with significant human rights problems where the government has actually sanctioned no one, that there is a vital need for us to use the Magnitsky Act more, and that's why we're introducing with this legislation a parliamentary trigger, a mechanism whereby if a parliamentary committee passed a motion calling on the government to sanction someone, the government would have to provide a response within 40 days or another timeline prescribed by the committee. It still leaves the government with discretion around who to sanction, and that's fair enough. The government will have access to information that the House won't, ultimately it's the government's responsibility to make these kinds of decisions. But we want to have a mechanism to have more accountability and more pressure on the government to actually use Magnitsky sanctions, something that they've been reluctant to do. So this is accountability for the government of Canada to push them to do more on human rights. Also, applying Magnitsky sanctions is about accountability for perpetrators of human rights violations. When we have human rights violations, Magnitsky sanctions are a way of saying to the perpetrators of those abuses, you cannot travel to or move your money to Canada. And hopefully, if countries work in concert to apply Magnitsky sanctions, this is a significant deterrent for human rights abusers who would potentially want to have an escape valve from the authoritarian regimes that they are a part of. Madam Speaker, I'll conclude with this. I think it's a powerful coincidence that the day this bill is coming to a vote at second reading is the anniversary of the death of Sergei Magnitsky. And I hope that we honor his memory and honor the memories of all of those victims around the world of human rights violations by passing this bill, bringing it to committee, studying it further, certainly looking for ways to improve it and strengthening it. But with this legislation, we can position Canada's foreign policy, not just in this parliament, but for generations to come, that Canada can be a leader on human rights, following through exactly what those communities we've been meeting with and people across this country want us to be doing. Thank you.
The Honourable Parliamentary Secretary to the Minister of Foreign Affairs.
Thank you, Madam Speaker. Advancing human rights is an integral part of Government of Canada's multilateral engagement and our foreign policy. And as such, it does not need, as the previous member suggested, ever need to be pushed